It's late. I'm sure I couldn't do much justice to a statement after Senator Isabella. I probably can't match the sensitivity and the depth and the feeling of the statement of my colleague Senator Winnico in beginning the discussion today, nor I'm sure will I be able to match the strength of feeling of my colleague Senator Burstein in closing debate. I just would like to respond to just one or two items that just keep coming up over and over again, which have been dealt with today, but I would like to respond to them again. And then I guess I'll just pull out Charlotte Perkins Gilman and read a little bit from her, because I think that even at the turn of the century, she had some pretty good ideas. Family breakup. We hear about family breakup. I just urge you, and we hear about the fact that we know nothing about what's going to happen. I mean, we are here as legislators. We have a responsibility to do a job. Well, we have 16 states that have equal rights amendments, some as far back as the ones that Senator Ornstein mentioned, some from 1970, 72, 74. But they're there. Take a look at them. Name me a state where these terrible things that you suggest are going to happen are really happening. The supporters or the opponents of ERA say, let us do it piecemeal, let us do it individually. They are the very same people who oppose the legislation that we have proposed before you in the last few years to do it on a piecemeal basis. We talk about losing the rights of, we talk about this wonderful right of support. We talk about the protections in a divorce or in a marriage. We have legislation and we bring it before you and we ask that it come out of committee and we ask for protections. We ask for financial disclosure for women on divorce, and we never see that legislation come to this floor. We talk about and I am no I'm a lawyer, but I'm not a constitutional lawyer, but we talk about the need to have down to the very last period the effect of this. Can you imagine Thomas Jefferson and Ben Franklin saying, hey guys, I'm not sure I know what this Bill of Rights says, we better not adopt it. We in this country are going to celebrate 200 years of a democratic republic, which is based in great part really on the magnificent document, our Constitution, and the flexibility that the language in that Constitution has allowed us, the flexibility to grow and develop, to believe, to love our neighbors, to work together, to have a country that survives for 200 years. Language that is broad, yes, but language that has been interpreted, language that we believe in, language that has afforded us the opportunity to sustain ourselves and to continue together as a country, a democratic country. We hear about rushing into things, well, I mean, again, 200 years, 100 years, 50 years. I've never seen, this is rushing. I'd hate to see what we'd be doing if we were walking in. The 14th Amendment. Senator Isabella, have you ever heard of the Frontiero case or the Reed case? And I'll name you other cases. In the Frontiero case, the Supreme Court of the United States specifically faced with the question of the 14th Amendment said and whether or not sex discrimination is prohibited under the 14th Amendment through the language of the person. In fact, decided that it would not find that a woman is a person under that, and said that it would look to see what was going to happen with the State Equal Rights Amendment. Frontiero case, 1974. You know, we have a great tradition in this state. We had Seneca Falls in this state. We hold these truths to be self-evident, that all men are and women are created equal, reads the Seneca Falls Declaration of Women's Independence. It went on. The history of mankind is a history of repeated injuries and usurpations on the part of man toward woman, having direct object the establishment of an absolute tyranny over her. He has never permitted her to exercise her inalienable right to the elective franchise. This was in 1848. He has compelled her to submit to laws in the formation of which she had no voice. He has made her, if married, in the eye of the law, civilly dead. He has taken from her all right and property, even to the wages she earns. In the covenant of marriage, he is compelled to promise obedience to her husband, he becoming, for all intents and purposes, her master. He has monopolized nearly all the profitable employments, and from those she is permitted to follow, she receives but little salary. As a teacher of theology, medicine, or law, she is not known. Be it resolved, wrote Elizabeth Cady Stanton, organizer of the Seneca Falls Convention, that it is the duty of women of this country to secure to themselves their sacred right to the elective franchise. And then her sister feminist, Lucretia Mott, added hastily in conclusion, the speedy success of our cause depends upon the zealous and untiring efforts of both men and women for the securing to women an equal participation with men in the various trades, professions, and commerce. I wanted to know what my feminist foremothers in this state, what they did after they issued their Declaration of Independence at Seneca Falls. And I learned with some satisfaction that they took this declaration to the New York State Legislature. It took a number of years. I mean, this legislature has never been known to move with particular speed on matters of reform. But in March of 1856, the Judiciary Committee issued a report on the women's petition for political equality. A Mr. Foote spoke for the Judiciary Committee because, as the man with the most years of marriage behind him, he was thought to have an inside track on just what it was that the ladies wanted. He rose to his feet, and this is what he said, and this is a quote, 1856, Judiciary Committee, New York State Legislature. Mr. Foote, the ladies, he said, always have the best place and the choicest tidbit at the dinner table. They have the best seat in the cars, carriages, and sleighs, the warmest place in the winter, and the coolest place in summer. They have their choice on which side of the bed they will lie, front or back. A lady's dress costs 3 times as much as that of a gentleman, and at the present time, with the prevailing fashion, one lady occupies 3 times as much space in the world as a man. If there is any inequality or oppression, Mr. Foote concluded, certainly the gentlemen are the sufferers. They, however, have presented no petition for redress, having doubtless made up their minds to yield to an inevitable destiny. This, my friends, is how the New York State Legislature first dealt with the subject of women's rights. Perhaps it is premature, but I believe today we will deal more responsibly, more honestly, more sincerely, more concerned, more lovingly with the question of the rights of all citizens in this state, and particularly women's rights. And for that, on behalf of myself, I thank you.
Senator Griffin.
Thank you, Madam President. First of all, I want to congratulate all the people in the gallery that's stayed on tonight. It's been a long afternoon and night. I want to apologize to the ladies. I need a shave. I was up since 7 o'clock this morning, so I didn't get to a razor. And thirdly, I want to tell a story about this debate. It reminds me of the couple whose husband liked to drink. So every night he was down at the tavern. So the wife said, well, I think I'll go down and just see what he does down there. So she went down, and the husband had a shot and a beer in the bar, and she took the shot and she drank it down in one gulp. And boy, it tasted terrible, and she spit it out. And he said to her, see, and you think I enjoy myself down here. Well, that's how it is about this debate, and I hope when you go home to your families, you know that we enjoy ourselves here in the Senate. On April 19th of 1972, the Federal Equal Rights Amendment was before us. There was only 3 of us that voted against the Equal Rights Amendment. Senator Niles, who isn't here with us, Senator Skimmerhorn, and me. I voted against this amendment because it was my responsibility to do so, because it didn't go to the people. And I was against that amendment, and I thought my voters, my people in the 56th district, were against the amendment. When this first passage came up a year ago, I voted for it because I want to let the people decide. I voted against Senator Eckert's amendment today because I feel it's a cop-out. And I want to see the people in my district, I want to give them a chance to vote on this. I have a lot of good conservative friends. They usually give me their endorsement. But I feel this amendment is a cop-out, and it's wrong for the people. I am personally against the ERA. My wife Margie is also. We have 3 young children, one 1-year-old, one 2.5, and one 5-year-old. She worked most of her life, my wife, but she enjoys the family, and I believe she enjoys me. When I voted against the federal amendment, I said, and I say this today, that we can right any wrongs through specific legislation. And I'm sure we can do that. And we're going to do it. My votes in the Senate have always been to protect women. Both the pro and the anti-ERA came to my office. And I don't think any of the 2 groups that came to my office represent the women in my district. Quite a few of them are loud, arrogant, anything you want to say, that's what they were. And an awful lot of them had an awful lot of foolish reasons why this should be passed or why it should be defeated. I want to read a couple of them to you. History should be changed to herstory. The playing cards will be revised because kings are ranked queens. Founding fathers should be changed to founding mothers. Of course, I think Golda Meir had about the quiver of them all. She said the ERA was silly, and I have to agree with her. The anti-ERA are worrying about women being drafted. I guess 6,000 women enlisted in 1973 and 14,240 enlisted in 1974. So I don't think we have to worry about drafting women. I guess they like the Army. There's one thing, though, I think is sort of funny. The ERA and Women's Lib, they call it chairperson today. And now I guess they want to have a chair one. It's sort of a limp expression, but I guess that's the vogue, I guess they call it today. I'm going to vote for this amendment so it can go to the people. I want to tell you right now, when it goes to the people, and I'm sure it will, I'm going to vote against it. My wife will probably vote against it. I don't know what she's going to do when she gets in that voting booth, but she said she's going to vote against it. And I believe the people in the 56th district will vote against it. One thing I hope that Senator Anderson will do, I hope he'll ask Senator Gordon to set up a task force of lawyers to go through some of the laws that might have to be changed because of the ERA amendment and bring these thoughts in front of the people so they know what they're doing when they vote for this thing. As I realized, I don't think anybody knows what this is going to do. I've seen too many experts in my 9 years down in Albany, so many constitutional lawyers, and most of the time they're wrong. Senator Brosnan read a letter into the record. It was a very good letter. But the same letter could have been written by one of the women in my district. And she could have been right on the opposite side that your letter writer was on, Senator, for the same reasons. This amendment is going to pass today, but I think it's going to be a bitter victory, and it's going to be a hollow victory. Because I think the people back home are going to defeat this amendment. Thank you.
That completes the list of senators that... Senator Winnicott, will you yield?
Yes.
Senator, the hour is late, so I'm not going to ask a series.
Senator Eckert, would you pick your microphone, please?
The hour is late, so I'm not going to ask a series of questions, but there is one question that I would like to have into the record. And that is, Senator, one of the leading advocates of ERA, Congressman Bell Abzug, insists that its passage would mandate striking of all laws restricting abortion. And it's a view concurred in by Professor Charles Rice of Notre Dame Law School and also by the former dean of the Notre Dame Law School. In your judgment, are these individuals wrong?
Senator, in my judgment, I believe they are. I believe the abortion, as we indicated before, is not and does not come under the Equal Rights Amendment, since it is a unique characteristic that only a woman can participate in.
Thank you, Senator. Madam President, on the bill. Every argument that I would have against ERA or the action of approving it, I think I indicated in statement of support for my amendment. But I would like to respond to Senator Griffin's belief that to not approve this is somehow of a cop-out, because I think that the debate here today, the statements made on all sides, has demonstrated that a great deal of uncertainty surrounds and clouds this issue, and it is my judgment that the legislature has a responsibility to present to the people those things that we deem worthy of their serious consideration. I maintain that if we ourselves, if this legislative body is so uncertain of the consequences, then it is irresponsible of us to expect that the voters would be more informed, more knowledgeable, and have a greater depth on this issue than we ourselves have. Obviously, they do not, and we as their elected representatives have a duty to be cautious and to present to them things of which we ourselves are certain. We can't ask them to be certain of it if we ourselves obviously are not. Thank you.
Senator Torriello.
Madam President, I had quite a few remarks I wanted to extend in regard to this amendment. I must be very brief. I wasn't going to speak then, but I feel compelled to at this time. I voted for the ERA last year. I campaigned for it during the election campaign, and I promised to my constituency that if I were returned, I would actively work for its passage. I pride myself, and I feel very honored to be a representative of one of the most progressive areas in the state of New York, the 55th Senatorial District. I'm going to vote for this, of course, and I think that history will record this day as a proud moment in the state of New York. I think this is a great day if this amendment is passed, and I'm honored to be a part of it.
Senator Nolan.
like to speak in favor of the EAR amendment. I must say that I had intended speaking earlier on the amendment, and I am just going to say one thing about it. I think that the New York Times, in its editorial this morning, was absolutely right when it called Senator Eckert's amendment a slick parliamentary maneuver in order to deny basically the people of the state of New York the right to vote on this very, very important and critical amendment. Now, I must say that philosophically, I disagree considerably with my colleagues, Senator Burstein, Senator Bellamy, on certain things, principally in the area of abortion and aid to non-public schools. And unfortunately, what I've found as far as the ERA is concerned is that a lot of people have mistaken, in my opinion, the reasons why they are against the ERA. They see many of the people in the forefront of the ERA as being connected with the Women Live movement, with radical women groups, and so on. And for that very reason, it seems to me they are voting against, or they want one to vote against the ERA. They are not considering what the Equal Rights Amendment itself does. And it very simply states, equality of rights under the law shall not be denied or abridged by the state of New York or any subdivision thereof on account of sex. I think that's fairly simple. Now, I can understand some of the non-lawyers in the chambers raising a lot of the issues that they have, but I really don't understand some of the more thinking attorneys in the chambers, such as Senator Padovan, such as Senator Santucci, who left earlier, really believing some of the things that they said here this afternoon and this evening in the chambers. They certainly, as lawyers, know that courts interpret laws based on common sense. Well, I guess maybe Senator Padovan is not a lawyer. Maybe that explains some of his thoughts. But certainly any court looks to the legislative intent behind the law. And I think it's very clear in reading some of the testimony, or a lot of the testimony that was given both at the hearings held by the United States Senate and by the hearings held in the legislature of the United States or the state of New York, what the intent of this Equal Rights Amendment is. And I think that Senator Goodman and Senator Branston both spoke very eloquently to that issue. And I have to disagree with Senator Knorr when he says that nothing positive was spoken about this. Certainly Senator Branston and Senator Goodman spoke about the equality of jobs for women. And I think this is very, very important. I've thought a lot about this amendment. I've done a lot of reading on it. I happen to have 7 children. 6 of them are girls. And I quite frankly share the tremendous amount of sympathy, shall we say, or how women are treated and how they're going to be treated in the future with regards to the job market. I think it's extremely important that a woman who decides, for whatever reason, that she wants to go out into the professions, that she wants to get a job and compete, or if she's forced to compete because of the fact that she has to help support a family or whatever. I think it's important that a woman has equal rights with regards to the job market. And basically that's what we're talking about with this amendment. And don't let anybody kid you. All this lot of nonsense that we've heard about the common toilets, the drafting in the Army and everything, in my opinion, is nonsense. We had Senator Eckert talking about some of the legal scholars who have some doubts about how these laws are going to be interpreted. Quite frankly, Senator Eckert knows that there are a lot more legal scholars that feel there aren't going to be any great problems with the interpretation of the Equal Rights Amendment. And the fact that Senator Ervin has a different opinion is certainly has his right to his opinions. And the fact that he was so involved in Watergate and so on, some people may tend to deify him as an attorney. We all know he's just another attorney. He may be a decent attorney, he may be a good attorney, he may be a good United States Senator, but he is certainly no better legal scholar than probably half the attorneys sitting here in this chamber. Now, I have intended to speak at length on this bill, but the hour is getting late. I too, Senator Griffin, need a shave, having not shaven since 6:30 or 7 o'clock this morning. And I think probably just about everything that could be said about the Equal Rights Amendment has been said here this evening and this afternoon. So with that, I would urge all of my colleagues to vote for the Equal Rights Amendment, and I know that you're going to see that in the future, a yes vote on this amendment will result in two things. Number one, the people of the state of New York overwhelmingly approving this amendment in November, and number two, seeing that the fears of some of the people in this chamber will not be justified, and that we will have a good law which will work well for the women in this state.
That completes the list of senators who wish to be heard that the chair knows of. Is there any other senator who wishes to speak at this time? Senator Ornstein, do you wish to close for the minority?
President, for the purpose of closing, I yield to Senator Burstein.
Senator Burstein.
My colleagues, I know how tired you are because I'm equally tired, and I would only hope that you would listen a little bit to what I have to say, because I intend in closing debate to speak both politically and personally. Things have changed in our society, all through it. Abigail McCarthy recently told us that nothing, in fact, would ever be the same again, regardless of what laws we passed or what constitutional amendments we enacted. For women live 30 years longer than they used to, and women have control over their own bodies, and women are better educated than they ever were. And what that means essentially is that for lots and lots of women, indeed for the majority of women, the substantial, overwhelming majority of women, there will be not 12 children in 12 years, but 2 or 3, perhaps 7. That woman, if she chooses to be exclusively in the home, will have nonetheless a whole area of time where she will not have the responsibilities of bringing up children, for her children will be grown. And it means as well that she will have a mind to look at the world around her and to weigh the consequences of the way the state acts on her and on the people she loves. Things changed in the society during the war, because when men went to fight, women had to keep the factories firing, sufficient to provide their men. And a lot of the shibboleths and prejudices and myths about the capacity of women were shattered. And after the war, when women went back into the homes, as they were encouraged to do, by again those who love to shape our society's ideology, they discovered that we were generating as a consumer society those kinds of labor-saving devices that gave them a tremendous amount of time. And so not only did they come back into the home with myths about their own capacity severely shaken, but as well they came to time, to leisure time, to look on their lives and to think about themselves. And what has happened in the course of that period, post-war, has been a very serious and vast change in the consciousness of the people of this state, led by a change in the consciousness of women, because they have seen that our society socializes us significantly differently, still still socializes us into myths that we should long ago have rejected. Everyone here who went to primary school and read Dick and Jane or the things that follow it know that it was typical to see that one section that said, see Dick run down the hill with Spot. See Jane watch Dick run down the hill with Spot. And people knew when they came home and they turned on the TV that the images that women presented would show them as not terribly serious, and often very frivolous, and utterly silly, because who, after all, should be crowned for having chosen a particular margarine? And when they went from the schools, where they were often given a broad and liberal education, out into the workplace, because they chose to or because they had to, they discovered again that whatever opportunities were being offered to their peers who were male were not being equally offered to them. You know that poster that they had about Golda Meir? The one that had on the bottom of it, "But can she type?" That is expressive of certain attitudes about women. So women go into the home, and they marry, and they are assured by us that there is tremendous protection for them. Well, that protection is the protection of love. Because if a man doesn't want to support his wife, and if he doesn't want to support his family, there is very little, ultimately, the state can do about it. You look at the enforcement records in our family and Supreme Courts, and you look at the desertion rates, and you understand that so long, in a sense, as anybody is dependent upon the goodwill of another person, as long as there is not that shaping of a whole social attitude and social laws that guarantee a measure of dignity and equality to people, that goodwill is too frail a reed upon which to depend. 9 out of 10 of your daughters will work in their lives. And they will find still that 4 out of 5 of them will be confined to the bottom rungs of the job and pay ladders. They will perhaps hold professional and technical jobs and earn only 68% of what your sons will earn. Women who are clerical workers presently earn only 63% of what men earn in that category. Women sales workers earn only 40% of what men earn in that category. Fact is, to come out of college today, a woman to come out of college today is guaranteed of doing only slightly better than a man with an elementary school education. That's clearly wrong. But it's a product of a kind of set of attitudes, a circle in a sense, because if we say women must be in the home and they will be protected there, then there is no reason to assure that if they leave the home, they will be given the same access and opportunity as male compatriots would be. And I point out to you that women who constitute 40% of our workforce aren't in there to buy luxuries for themselves. They're there because their husbands don't make sufficient for them to live. They're there because they are widowed, because they are divorced, because they are single. But it isn't only the people in the workforce whom we are out to protect, not to protect, but to offer opportunity to enhance themselves to. It is those women who are in the home, because to foster the notion that dependency is purely sex-related is to diminish the value of any individual. Now, I would like to say to you, I said before that I would talk personally, and I will just with 3 incidents. There's a woman in this legislature, covers it. She's a reporter. She will be the first woman bureau chief of a major newspaper. She once, in her reportorial function, interviewed a man in one of the great university clubs in the city of New York. And in order to interview him, she had to walk behind a panel, and he couldn't walk with her until they found a room where they could sit down together. And then on walking out, she was again told that she could not walk through the main part of the hall, that it would offend people, and that she would do something devastating to their own sense of themselves, and therefore she must again walk behind the panel to come out. That's changed, but it's changed as a result of the legal pressure of women in this state. When I came to the legislature the first time, I know I look young, and it's anomalous to find a woman senator, and I expected that they wouldn't let me in the assembly until I showed my pass. But when I walked in at 12 o'clock one night on a Sunday, and a guard said to me, "Show your pass," and I said, "I don't have to. Senators don't have to show passes." He said, "You show your pass." And I said, "I'm a senator, I'm going to my room, it's 4:05, and I went up, and as I said, it was very late, and I would assume that no secretary or aide in this office, in this legislature, is so exploited that she will be working at 12 o'clock on a Sunday night, so it must only be a senator, crazy enough. But he was late, and I was nervous, and he was big, and I heard a knock on my door, and I opened it cautiously, and he pushed his way in, and he said, "You show me your pass." So I took my pass out, and it had my picture on it, and he looked at it, and he turned it over, and he looked at it, and he said, "My God, I hate to call women senators." Now, that doesn't make one feel tremendously at home. And it makes it much more difficult, the task that I have to do here, that my female colleagues have to do here, although it has improved considerably, and I've enjoyed, particularly this last year, working here in this legislature, because I have seen also a change in all of our consciousness. And that change, it seems to me, allows us to come to the point where we are prepared for second passage of the Equal Rights Amendment. And those who would say we ought not to support it, those who would say, and they are many of them women, that we are all right, and indeed we are very well protected by our husbands, and we do not want anything to change for anyone else, although our lives will not change. Those who say there is division among women have forgotten a fundamental truth, a fundamental statement about the relationships of human beings, of women in this particular case, which was attested to by a black woman slave who was born in Kingston, New York. And I want to read her statement into the record because we have hidden heroines in our history, and it is time that some came into the light. Her name is Sojourner Truth, and she said, "The man over there says women need to be helped into carriages and lifted over ditches and to have the best place everywhere. Nobody ever helps me into carriages or over puddles or gives me the best places. And ain't I a woman? Look at my arm. I have plowed and planted and gathered into barns, and no man could head me. And ain't I a woman? I could work as much and eat as much as a man when I could get it, and bear the lash as well. And ain't I a woman? I have borne 13 children and seen most of them sold into slavery, and when I cried out with my mother's grief, none but Jesus heard me. And ain't I a woman? If my cup can't hold but a pint, and yours holds a quart, wouldn't she be mean not to let me have my little half measure full?" Sojourner Truth said that, and it still is true as it was in 1851. And it will, that truth of it, I think, confirm all of us in the wisdom of the action we take today, because all of us, the ones who are women, and you who are our brothers, the men in this legislature, know that we have all of us been cheated as a society by the fact that we cannot, any of us, escape under the laws at this moment the accidents of our birth. And if we are to experience ourselves fully, to know all our human potential, it will be not directly as a result of the Equal Rights Amendment, but as a result of a beacon of light that Equal Amendment shines on our statutes in the state of New York, and on our own attitudes, the attitudes that inform statutes, that keep people down, that keep people in positions which they ought not to have to suffer from. I ask those people who didn't yet cast a vote and who have not yet made up their minds to join us, to join the named, us who are named, in the sponsorship of this bill. I would read them out, but you have it in front of you. I would only say that I believe those of us who co-sponsored this measure and those of you who joined us in voting for it constitute an honor roll for the state of New York. Thank you.
Let me say that I would not in any way attempt to match the deepest sincerity and eloquence that has just been displayed by Senator Burstein. And perhaps it's because I am not a woman that maybe I can say a few things with reference to this amendment, some of which have been said probably better than I'm going to say them. But before turning to that very briefly, let me say that this bill, or this amendment, was passed in 1974 in all candor, without the hearings that perhaps it should have engendered, and for whatever reason that may have occurred, certainly this year, under Senator Gordon and the Judiciary Committee, there was ample opportunity for everyone to express themselves, for every thought, whether it be in the philosophical era, the legalistic, to be given a full airing. We didn't have that before. In candor, we didn't have it in the Assembly at the time they passed the bill this year, but it was a fact that Senator Gordon had a full and complete hearing on this subject in which everyone had an opportunity to express themselves. My reason for supporting this amendment is absolutely the same reason I had in 1974. When we pass laws and amendments in this House, most of us hope that they're going to work. Most of us hope that they're going to bring about the result that we envision when we draft them. Most of us have an aspiration for instant success. And I guess that we wouldn't be here if we didn't have that kind of faith and that kind of confidence in what we were doing. I think that in this field that we're dealing with this evening, instant success is too much to expect. What we're dealing with here is something that those of us who are not women probably don't understand, because we're dealing with their confidence in themselves. Now, we've had a lot of laws, we've passed a lot of laws, we're going to pass some more. On this and other subjects. But here and now, this evening, if the people of this state in November agree with us, we're going to put in the Constitution of New York something that should have been there from the very beginning. We're going to say that the women of this state are equal to those of us who are not women. We're not going to say that they're the same. We're not going to say that at all. And I've heard a lot of conversations about that, and I'm not going to go into that because it's been exhaustively discussed. We're going to say they're equal in opportunity. Now, no piece of legislation is going to make that happen. We know that. We absolutely know it. But we also are going to know, I think, that legislation helps change attitudes. Not just about how men may think about women, but how women may think about themselves, as a matter of actual fact. Now, there's nothing in this piece of legislation that's going to make all women become atomic scientists or state legislators or whatever you want to talk about. But I want to say that there's something that is here, it's going to be said loud and clear, that if a woman wants to become an atomic scientist, she can. And the only thing that will keep her from being that is her own will, or frankly, perhaps her lack of ability, which would certainly disqualify me and probably everybody else in this room from that category. There's nothing in this piece of legislation that says that a woman can't aspire to be a housewife and a mother, which certainly everybody in this room recognizes are two of the most important things that any person in this world can ever aspire to. What we are saying that this is a decision that some individual can make. Maybe some genius can be both. Now, some have wondered out loud and speculated in their minds as to how this amendment is going to work. I think it's going to work wonderfully well. I think it's a long step toward changing an attitude and making the Empire State of New York one of those states that is completely concerned with everybody that lives in it. So let me say that when I vote for this, as I voted for this amendment in 1974, I vote for it with no reservations, none. We may pass a lot of things in this session. I'll guarantee you one thing. In the year 2000, the only piece of legislation that's going to be remembered that we passed in 1975 is this one. And I think everybody in the House ought to vote aye.
The question arises on the concurrent resolution before the House. The Secretary will call the roll.
Anderson, Bloom, Conklin, Markey, Ornstein, Warder, Winnico.
Senator Markey.
Madam President, in explaining my vote, certainly Senator Burstein explored very sensitively, I think, the whole bundle of factors that go into religion, into spirituality, into culture, into social attitudes, and everything that was said here today in analysis really was not inconsistent. And I think that some of the media that has taken pot shots at Senator Eckert, who I think reflected those very same concerns, and did it in the context of how we best preserve them, that ultimately we come really to a common consensus on the question of rights before the law, the one advanced by the proponents of this legislation, I think, which goes to the question of where the burden really rests in asserting these values as they are re-examined, and the thesis, of course, that Senator Eckert presented, which I had supported and still support, that this rests with those engines of change who must reconcile it to the public interest. The difference is very narrow, but it's not a distinction without a difference. And certainly a case has been made out to move out to the larger jury, which is the public of the state of New York. And in doing this, I don't think that we should be divorcing ourselves from that process. I think that as we acquire some distance between our deliberations and the vote which the public will be ultimately asked upon to make in November, that we will be part of that process, that we are not passing this question on to them and divorcing ourselves from its significance. We're enlarging the jury because it deals with a very fundamental social question as well as a political and governmental question, a question of personal rights. And enlarging that jury, which is the sum total of our New York State community, we should think in terms of being a very intimate actors and participants in that deliberative process. So that I feel that the case has certainly been made for movement towards that greater jury, and for this reason, Madam President, I cast my vote in the affirmative.
Would appreciate a show of hands again on the negative votes. That is unbelievable. That is unbelievable.
Those recorded in the negative are Senators Auer, Calandra, Donovan, Eckert, Hudson, Isabella, Johnson, Knorr, Lombardi, Padovan, Rollison, Santucci, Skimmerhorn, and Volker. Ayes 44, nays 14.
The resolution is adopted. Senator Anderson, just a moment, please, Senator. Will the House remain in order, please? There's a little more business to transpire this evening.